Hello and welcome to another bonus episode of Stand Up. I asked Eric Segall if he could talk real quick. Eric, can you talk real quick? And there's plenty of things to talk about that have been transpiring both at the Supreme Court in Fulton County and elsewhere that I wanted to ask him about. So we covered a couple of the arguments that were heard at the Supreme Court, and we also talked about the big decision by the Supreme Court to kick the can down the road on deciding whether or not Trump will be given immunity or if presidents should be given immunity. Of course, they will decide that he doesn't get it. At least 7 of them should, but not for another 7 weeks. Big news yesterday, and that is where we start with Eric Segall. Thank you very much for pressing play, for listening, supporting the podcast, patreon.com/Pete Dominic. Let's do it right now with the legal eagle, Eric Segall. Oh, yes, there he is. You asked for him, and I got him. There's a lot for you to weigh in on, my friend, and obviously, and most importantly, the Supreme Court's decision to hear Trump's case on whether or not he can order a Navy SEAL to kill his political opponent. But also, not only are they going to hear it, because they didn't have to hear it, because the lower court decided, and it was pretty ridiculous, but they'll hear it in 7 weeks.
It's unbelievable, Pete. I tweeted out this morning that I was interviewed by a French journalist. Look at me, Louis.
So I was too. They asked for me first, and then I told them to talk to you.
And it's not, I mean, okay, we're going to talk about the immunity case, all the Trump cases in a second, but abortion, guns, administrative law, Trump, and all kinds of other huge cases this term. It's going to be a hell of a term, and I think my idea is it's going to be scary and sad. So here's the deal. Donald Trump made the absurd and stupid argument that presidents can never, ever, 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 ever be prosecuted for criminal activity unless they are first impeached by the Senate. Everybody knows that the Senate impeachment procedures are 100% political and have no basis in anything that is real or logical, except for politics. So what that means is that oral argument in the D.C. Court of Appeals, and one of the judges, by the way, on the D.C. Court of Appeals was a very Trumpster judge who's done some pretty terrible things in Trump cases. They asked the lawyer, what if the president orders SEAL Team 6 to assassinate his political rival?
Yeah.
And the answer was no criminal prosecution unless he's impeached. That's obviously not correct. A unanimous D.C. Court of Appeals decision said that's not correct. All Americans know that's not correct. We don't live in 1790 England, although I'm sure at least 5 of the Supreme Court justices wish that we did, but we don't. We don't have King George. And so that's what, Trump's going to lose this eventually. The court had a number of options available to it when D.C. Court of Appeals ruled. It could simply have said, and they do this a lot, we agree with the Court of Appeals, and the decision is affirmed on the basis of the Court of Appeals, which is called a summary affirmance, and it's a very regular thing at the Supreme Court. They could have done that, and Trump could have been in trial in a month. He could have been in trial in D.C. in the middle of March, but they didn't do that. They could have refused to take the case and said, come to us later.
Right. Go
on with the trial. They didn't do that. Instead, they granted cert. They put oral arguments 6 weeks away, which means the decision is at least 9, 10, 12, more than that, weeks away, meaning we're already in the summer, meaning the chances of this being a trial that's completed before Election Day is very small. And I have a theory as to why the Supreme Court did this. Your audience and most political scientists and most smart people who aren't law professors would agree with this theory. It is only law professors who might disagree with this theory.
Go ahead. I want to hear it.
I don't think they will. So this is very complicated, Pete, for the Republican justices on the court. This is not easy for them. If you're sitting in their chairs, unless you're Alito and Thomas, maybe, who just want Trump to win everything all the time. For the rest of them, it's complicated. Pete, their first duty, they're going to say their first duty is to the Constitution. But you and I know their first duty is to the court and to the history, what history will say about the court. That's how they view their first duty. Their second duty is to the Republican Party, and their third duty is to the law. So in normal times, it is clear what the Republican Party's interests are in cases like this. In Shelby County, the Republican Party's interest was get rid of the Voting Rights Act. In Bush versus Gore, the Republican Party's interest was get rid of Al Gore. That's what it was. It's obvious. In numerous other voting cases, the Republican Party doesn't want people of color to vote. So the Supreme Court has given us a country where legislators are allowed to make it harder for people of color and poor people to vote.
Yeah.
In this case, what's in the best interest of the Republican Party is unknowable. It's just unknowable to you, me, and Justice Kavanaugh. No one can predict. We're in too much of a crisis, too much of a bizarre time period. So what I think they're trying to do is Trump will lose this on the merits. He's not going to win the immunity. He's not going to be disqualified. This whole thing is a package. So the question then becomes, if he's not going to be disqualified and he's not going to get immunity, and both of those things are true, then how do we time this for the best interests of the Republican Party? And the Supreme Court must have decided that the best interest of the Republican Party is in not delaying this too much, because that would look to be purely partisan politics, right? If they said, we're going to do it next term, so the trial can't happen until after that, the American people wouldn't have accepted that. I don't think. The American people would have gone crazy. So what are you talking about? You're going to put this off for a year? That's ridiculous. But if they did what I thought they should do, and I think what Rick Hasen and other election law experts thought they should do, which is just affirm the Court of Appeals, then the trial would have happened quickly. That would not be in the interest of the Republican Party. So they're trying to walk this tightrope. The key takeaway there, of course, not about Trump, which is not my field of expertise, but about the court, is this is a court, again, not acting like a court, but a political institution.
Just to be clear, Jack Smith went to the Supreme Court and said, on this immunity question that Trump's lawyers are asking, why don't you go ahead and just take it? Take it right now and decide right now, because we all know what you're going to say. And so go ahead and take it. And they said, no, we're good. And so the D.C. court took it, and they decided unanimously.
Including a Trump judge who's very conservative.
And then after that decision, that one-page decision or something comes out, the Supreme Court then the next day could have said, yeah, we're not going to take it, or we're going to take it right now. But they waited a couple weeks.
Well, maybe not the next day, Pete, because briefs have to be filed, but within 30 days, yes.
Okay, within 30 days. But,
yes.
And the reason I say that is because the timing of the other case that has been brought to the Supreme Court that they're going to hear about the ballot and whether or not Trump can be on the ballot, as 3 states, and last night Illinois, have decided he can't. They took that pretty quickly.
Well, the irony here, Pete, is almost too much to bear. And by the way, that you should have this person on your show if you can get him. I'm sure you could. Steve Vladeck is the person to talk to about this. He wrote the shadow docket. But here's the irony. There have been moments in American history, but only isolated moments, where the court has acted incredibly quickly. Can I go into that for a second? Because It's kind of interesting. So it's the Korean War in the early 1950s, and the steel mills are going to go on strike. And President Harry Truman believes, or at least he said he believed, that if the national steel mills go on strike, we won't be able to build tanks and weapons and bombs for our troops in South Korea, and Americans will die. And that's what he said. And so he said, and Congress wouldn't act. He said, Congress, do something. Congress wouldn't do anything. During World War II, the president seized numerous plants to fight World War II and made them kind of, employees of the national government just for the war effort. So that's what Truman wanted to do with the steel mills. From the second he did that, he announced, we're taking over the steel mills tomorrow. I will do whatever Congress says, but if Congress doesn't act, I have to act. From that moment of time into the final Supreme Court decision was about 3 months, I think, 2.5 months. The court acted incredibly quickly, and that was a really hard legal issue. That was a much more difficult question. When the Washington Post and the New York Times said they were going to publish the Pentagon Papers in the early 1970s, and the government argued, Nixon argued those papers had top secret information, shouldn't be disclosed, the court acted incredibly quickly. But that's rare. And Bush versus Gore, they acted incredibly quickly. But that's incredibly rare, except for the Roberts Court. And Steve Vladeck, who's the expert, would tell you the Roberts Court has decided more questions on an emergency basis, on an expedited basis, in a matter of days or weeks. In the last 6 years, they've done that more often than the previous 50 years.
So, that's what I'm looking at his Twitter feed, and he says, Steve Vladeck,
yes.
I'm not defending the timeline here. My own preference would have been the court to deny the stay outright, but we ought to at least account for the court that we have rather than, or at least in addition to, the court we might want when asserting these kinds of considerations. Two different things can be true. SCOTUS is not moving as fast as it possibly could, as fast as many folks want it to, in resolving Trump's immunity appeal. And the other thing is, SCOTUS is moving much faster than Trump wanted it to, and much faster than it does in virtually all of its cases.
Well, but yeah, Steve wrote that, but he also wrote sometime in the last 2 days that the Roberts Court knows how to act fast when they want to because they've done it all. But part of that is not the Roberts Court's fault. Part of that is COVID and the emergency and all those emergency motions we had during COVID. But here's the main point. When they want to act, first of all, the Supreme Court as an institution over his history can act quickly when it wants to. The Roberts Court has been the fastest court in American history by far. It's not close. They've acted quicker than any other court in more cases, and it's not close. And Steve's book talks all about that. So, yeah, I mean, he's right. But again, remember, what Steve is saying there, the court is not acting as fast as we would like, but it's acting faster than Trump would like. That's the soft middle point those politicians wanted to reach, where liberals would say, well, I wish you were going faster, but conservatives are saying, I wish you were going slower. So everybody gets a little bit, nobody is too pained, and we found the middle ground. That's what they've done with Trump since he became a public, a presidential candidate. He's lost a bunch of cases in the court. He's won a bunch of cases in the court, but it's always kind of a little bit of this and a little bit of that. The problem with that here, not according to Segall, but according to 3 different election law experts, Ned Foley, Rick Hasen, and a third, who filed an amicus brief in the court on all these cases, what they're saying is whatever you do it quickly. Get this wrapped up quickly so Americans know who they're voting for, who they're allowed to vote for, and whether the person they're voting for is a convicted criminal. Please do this quickly, and the court is not doing it quickly. Except for one more thing. The court's not going to say he has total criminal immunity. Right. There's no chance of that.
Right.
Go ahead.
Okay, so I want to ask you about what's going on in Georgia, because events transpired in the Fulton County case this week. I didn't pay attention to it. I saw you were tweeting about it, but my only question is not what happened, but what is the likelihood of this judge now deciding that there's an issue and throwing this case out, which you told us last time would mean that the case is gone because no other prosecutor in the entire state would take it up other than in Fulton County. So whatever transpired this week, what does it mean for the continuation of the case?
Pete, it's been such a showdown here. So let me just say a couple things quickly. As your audience probably knows, I am not an expert on criminal law, but over the last month, I have learned a lot more than I ever knew, and I've become pretty knowledgeable on this procedural stuff. But I do not consider myself like a world expert on criminal law issues. I think the judge has a really hard decision to make. I don't think he's going to disqualify anybody, but it's a close call. And I would not want to trade places with this judge. And no matter what the judge does, no matter what he does, now we have to worry about appeals and delay. And I want to say one more thing. One thing that I have absolutely decided over the last month about this case is whether or not there's a technical legal violation. And I think that's a close call. And that's why the judge has had a number of hearings. And that's why 2 of my colleagues, Pete, have been on CNN and MSNBC and all over the place talking about this case. 2 of my trusted colleagues. Anthony Christ and Clark Cunningham.
Yep.
And they disagree on what should happen next. So I'm not going to give you a definitive, he should do this, he should do that. What I do know is the issues are substantial, and this should never have happened. If you're going to prosecute a former president and the GOP frontrunner, in this year's election, if you're going to do that, and you should, Trump unequivocally should be prosecuted in Georgia, because this is where the phone call happened. And that phone call is by far and away the strongest. That and not doing anything about January 6th while he was sitting there watching the Capitol get invaded. Those 2 things are the most important facts, but especially the Georgia phone call. Just find me one more vote than I need. I mean, there's no way to spin that phone call. I don't care what Trump says. So this is all sad. But like everything else going on, what's going to happen is I think it's going to be delayed so long that it's not going to affect the election.
What do you think about the Trump Stormy Daniels case, which is going to proceed? The hush money trial is going to proceed, and that's a case that will not be complicated for Americans to understand and to follow. Lawrence O'Donnell was talking about that last night. saying that this is a case that is going forward. We're going to watch this happen, and he could be in big trouble there.
He's not in big trouble there. The court, if he gets convicted, the Court of Appeals will reverse it. If the Court of Appeals doesn't reverse it, the Supreme Court will, just like they reversed the conviction of that terrible governor in Illinois, whatever his name was.
Blagojevich.
Yeah. And a bunch of other white collar criminals as well.
Okay.
Yeah, Pete, I don't, the Stormy Daniels case, I wish you hadn't asked me actually, because that case should never have been brought. It's a very technical look, what he did with Stormy Daniels is terrible. And the American people should look at that and go, the guy was married and he's paying off a stripper, and these evangelical Christians who love him should go, what the fuck? They won't.
But it's an FEC violation.
Well, Pete, it is, but it's a novel legal theory. And
right.
these kind of violations, frankly, Pete, don't get prosecuted.
Is that your friend Steve Vladek's opinion?
I don't know what Steve thinks about this, but that is that when the case was filed, I very carefully read a lot of election law experts on this.
Well,
and I think Rick Hasen agrees with this. It is you don't bring an on the line case with a novel legal theory against the president of the United States. You just don't.
All right. Well, we'll see what happens there. Let me ask you about on Wednesday at the Supreme Court. They heard oral arguments in a case called Garland v. Cargill, and this is about guns. It's about
this is great. Yeah, go ahead.
The Trump-era ban on bump stocks as devices that turn weapons into rapid-fire, illegal machine guns. It's unclear that the majority of justices would ultimately back such a ruling or agree on the rationale. I'm reading from ABC News reporting on this. Both liberal and conservative justices suggested the devices, which allow a shooter to fire a semi-automatic rifle more rapidly and accurately, pose a significant danger and could reasonably be considered the types of weapons Congress sought to outlaw in the 1934 National Firearms Act. Segall, I heard some of the arguments, and it was very technical about how a gun fires, how a bump stock works. Like, I must have heard 15 minutes of back and forth with the justices and one of the lawyers about that. What the hell happened? And is it likely that everybody's going to be able to own a machine gun soon?
Okay, so let's go back. There are a few big things I do want to say about this case. First of all, it's not a Second Amendment case. So everybody just stop. It's not a Second Amendment case. It is the case about whether the federal agency that determined the definition of what is a machine gun did it correctly. So we're back to administrative law, and we're back to all of that major questions doctrine and all that stuff. It's not a Second Amendment case. Second, and Pete, this is the most important point I'm going to make. What we're fighting about here, we meaning the people who want this kind of bump stock to be banned and those who don't, what we're fighting about is whether the federal government properly classified what is a machine gun. And what we're arguing about is whether what you called it a semi-automatic weapon can be turned into an automatic weapon by this bump stock, which then turns it into a machine gun, which is then absolutely illegal under federal law. The question is the definition of a machine gun valid? But Pete, semi-automatic weapons can do unfucking believable damage. I mean, that we're at the point of American history when what we're fighting about is whether to turn a lethal killing machine that can kill a lot of people in a very short time into an even more lethal killing machine that can kill even more people. And this is absurd. Like, think about what we're discussing here. I mean, no other country has this conversation ever. These guns are banned everywhere, all over the world. Sorry.
What does the Constitution have to do with this specific argument about the capability of any machine?
Nothing. Well, again, this is not a constitutional case. This is an administrative law case. This is the federal government properly interpreting. The federal statute bans machine guns. A fully automatic gun, my understanding is a machine gun. Now we have a semi-automatic gun. You put something on it, and it becomes a machine gun. Pete, Nick Bagley, a professor at the University of Michigan, who was one of the best professors when it came to Obamacare years ago, I think he has some kind of healthcare background. He wrote a thing on Twitter yesterday that is fabulous about this case. What he said was he had this very case like 12 years ago. When he was a young lawyer working for a big law firm. They had a case not involving this particular bump stock, but a different kind of contraption that turned a semi-automatic gun into an automatic gun. And this is what happened to that case, Pete. It's unbelievable. Eventually, it got to the 11th Circuit Court of Appeals, a very conservative court, and a panel that included your friend and mine, Bill Pryor, one of the worst judges in America, the judge that hired the woman who said I hate all black people, the judge who went to the Federalist Society and made fun of Dahlia Lithwick and Mark Stern in public, gave out their names. A terrible judge. The 11th Circuit, in an unpublished decision, it wasn't even an important case, said, of course, the federal government can define a machine gun this way, and it's not close. They didn't even have oral arguments.
But just to be clear, I feel like I haven't stated it. I haven't done a good job.
Okay.
This case was about whether or not the government can ban something called a bump.
No,
bump
I wish it were about. No, I wish it were about that. It's not about.
Well, it's about whether or not Congress agencies should have any jurisdiction over it.
It's about that Congress. Okay, we know. I think we know. Let's hope we know that if Congress bans. There's a federal law that bans machine guns. That law is constitutional. It was upheld in 1937 or 38 when the Supreme Court said the only thing that the Second Amendment prohibits are, guns related to militia use, and what you and I think is the right interpretation of the Second Amendment. So Congress can do this. The question is what the federal government, the president, the executive branch, defined as a machine gun, is that consistent with the statute? When Nick Bagley had a very similar case a decade ago, because at that moment in time, even like Justice Scalia would have deferred to the agencies. It was all about agency deference. If the experts say this is a machine gun, we're going to go with them, unless they're really wrong.
Right.
And that was such an obvious thing to Judge fucking Bill Pryor, so that they did an unpublished opinion, like a paragraph long, saying this case is easy. Government wins.
But everything has changed with the Supreme Court. Nicholas Bagley tweets after he explains the case that he had years ago. He says, the point here is just that the case was a nothing burger as recently as 15 years ago. Agencies got deference for reasonable interpretations of their statutes, and there's nothing unreasonable about what the ATF did in the case that he's talking about. But, he says, administrative law is shifting under our feet, especially in hot-button political domains. Agencies aren't getting the kind of deference they used to. And so you have a morning at the Supreme Court consumed with a legal question that, in my view, should have been treated as summarily as the 11th Circuit treated the case that I once litigated. And
so can I say something light and frothy for a second?
Oh, please. I'll take one light and frothy, please.
Mr. Professor Doom and Gloom is going to say something light and frothy. I think your audience is old enough, I could be wrong about this, that they remember the movie Broadcast News.
Yeah,
and it's a fantastic movie. By the way, it holds up. Watch it tonight if you haven't watched it. Anyway, there's a scene in Broadcast News where Albert Brooks, who's the producer of a news show, is feeding lines to William Hurt as the news anchor. And at one point, Albert Brooks goes, "It's so weird. I say something in the microphone and it comes out on TV in the mouth of William Hurt, the anchor. I mention a tweet, and 30 seconds later, you have the tweet, you have the entire dialogue, and you say everything I should have said, but better, and I'm very impressed by that."
Oh, yeah, you should be.
I am.
I'm very nimble here.
You are nimble. I could not do what you just did, which is look up a tweet.
You know what's even more impressive is yesterday I did that, but with a Pulitzer Prize winning author on his new book. Like, I was able to reference a thing he brought up because I had read the book and earmarked it and written all over it. And that's why I should be up for awards.
I agree. The second time you and I ever talked was about Citizens United, and you were already up to speed.
Not one award ever. In my
you
career.
have the Segall.
I've never been honored. There's no awards.
Yeah, but you have an audience that loves you. And by the way,
I have an audience that makes fun of me, which is why I realized what I just did there. I almost want to edit it out because in Vegas, I guarantee they're going to present me some joke award that's going to be hilarious and humiliating at the same time. And if it weren't for me,
well, that's hilarious. What you are. You're hilarious and humiliating.
Yeah.
But Pete, what I want to say, no, I'm kidding, of course. But Pete, what I want to say is every time I go to my Facebook, which I don't do very often, I'm more on Twitter, and I see your Las Vegas Lollapalooza
PodJam.
It just kills me that I can't be.
Yeah.
I love you. I love Vegas. I love everything about it. But my family comes first. It's nothing I can do. But
we thought you were going to be there, and it is shocking that your family comes before us. I feel like we've I feel like many of us are as, if not more important than at least some of your family.
I'd like to delete that last comment and rephrase it with this one. My first family comes before my second.
Oh, look at that. How sweet is he? All right, let's get to this other case. I've got to just have you weigh in on. I know you've got one thing at least to say about the Supreme Court hearing the social media moderation and content laws. And this is, I guess, ostensibly some kind of a First Amendment for the 21st century issue. It seems like it's a legitimately difficult thing to weigh in on and understand what social media platforms should be able to do. But what is your thought on it?
Well, so if I were a constitutional interpreter without the benefit of 100 years of Supreme Court cases, I would say this is a hard case.
Oh,
it's a hard case because normally the Constitution does not apply to private companies. You can't. The government. Strike that last sentence. The government can't make private people speak in their private capacities when private people don't want to. If I want to have a dinner party for 100 and say no Republicans allowed, I'm allowed to do that in my house. If Exxon wants to have a corporate dinner party and say no Republicans allowed, Exxon is allowed to do that. And of course, the government cannot tell newspapers what to print and publish. They actually tried that in the 1970s in a Miami case involving the Miami Herald, one of the Miami newspapers, where some Florida law wanted to make sure that they give equal time to this or that. And the court said, no, you can't regulate newspapers. To the extent Twitter and Facebook are like newspapers, they're private companies in the media business. No, the Texas and Florida can't make them drop certain people or not drop certain people or whatever. The argument on the other side is that Facebook and Twitter are more like common carriers, like trains or planes or automobiles.
Right.
And therefore they can be regulated. I think that argument is stupid. They're not like planes, trains, and automobiles. Twitter is quintessentially a free speech, First Amendment communication company. And Florida and Texas should not be allowed to tell them what to do absent the most compelling of reasons. Do we have the most compelling of reasons? I don't know. Maybe. I don't know. It's all new. It's really new. What I will say this, Pete, just like in the last case with Nick Bagley talking about administrative deference, without the Trump judges, this is an easy case. The laws get struck down as unconstitutional, and it all goes away very quickly. The Roberts Court has used the First Amendment as a type of supercharged nuclear constitutional provision to invalidate all kinds of things that don't even involve speech. I want to give one example. There was a case in the 1970s involving public sector unions. So Georgia State University employees or New York State public employees.
Yeah.
And whether or not you joined the public union, you had to pay dues. Some people challenged that under the First Amendment and said, we don't want to pay dues if we don't have to. We don't want to be forced to pay dues because the union sometimes takes political positions we disagree with. The court very quickly said, that's not a First Amendment problem. Don't worry about it. The Roberts Court reversed it and said union members have a First Amendment right not to pay dues, which is bizarre, wrong, and a bad use of the First Amendment.
Yeah.
They've done that on numerous other occasions. So this is a court that loves the First Amendment. So this case should be easy for them. No, Twitter and Facebook get full First Amendment protection, just like those union employees get full First Amendment protection. Should be an easy case. But because of the political stakes, because somehow, and by the way, I don't even know how this is happening, but somehow the right is portraying social media as, left focused. Twitter is not left focused anymore. Anybody who thinks that is fucking insane. So I don't know what's going on with that. It is only a hard case because of the people on the court, but at the end of the day, they're going to strike down both laws.
Do you have to go, or do you have time to talk about your piece?
I have 10 more minutes.
Well, you wrote a piece at Dorf on Law, Justice Thomas and Race, Making Life Harder for People of Color, One Case at a Time. This was your contribution to Black History Month?
No, this is my contribution to trying to build a lifelong legacy of scholarship that suggests Justice Thomas is the worst Supreme Court justice in American history. And 50 years from now, when I'm long dead, people will say, Segall knew.
I'll be alive, and that's all I'm going to say, because I'll be so old that it'll be I'll be senile, so I'll be like, Segall knew, Segall no, Segall no. I'll make a whole musical dedicated to you about all the things you knew. If you listened to Eric Segall, you would have known too, because Eric Segall. Okay, so
no, this is what. Let me be serious. Let me go back.
Yeah, this is a very could be seems controversial, I suppose, but I don't think it is.
So the only thing I didn't say in this piece was the thing I'm not. All my friends tell me I'm not allowed to say, so I'm not going to say it either. Here, I'm not going to, because they tell me my career will be dismantled by this. But here's so I'm not going to use the adjective to describe what I think Justice Thomas is.
You've accidentally used it in the past and then asked me to delete it. So you don't want to dehumanize a black man, is what you're.
No, that's not. Nope. That's not the reason. The reasons are stupider than that, and it's the only time in my career I've ever self-censored.
Okay, well, now that we don't know what that is.
What I did write was, if you look at Justice Thomas's jurisprudence as a whole, it is not debatable that his opinions have done enormous destruction to people of color. And the reason I wrote that, and I went through whether it's affirmative action, voting rights, actually, Pete, it's in criminal procedure cases where he really has been terrible. I mean, he's terrible in all those cases. In criminal procedure cases, he is by far the worst of anyone.
What's an example of that?
I'm going to give it to you. There's a famous landmark case called Gideon versus Wainwright from the early Warren Court, where they said, for the first time in American history, if you're accused of a crime that has, I think, more than 1 year, a felony, if you're accused of a crime with a year of prison sentence or more, although I'm not even sure that's the rule, and you can't afford a lawyer, the government has to provide you a lawyer. Like that's, and all Americans know that case. That's if you can't afford a lawyer and a lawyer will be appointed for you is a line that all Americans know from Law and Order, from a zillion other cases. That is one of the most important cases in Supreme Court history. Thomas has said he wants to reverse that case. And if he reverses that case, what that means is, if you are an indigent, poor person on death row facing the death penalty, you don't get any lawyer from the state. That would have a disproportionate effect on racial minorities, of course, and it would and he wants to overturn one of the most important landmark cases in American history. But that's just one example. Pete, when the state police illegally search your house and take evidence from you without a warrant and without probable cause, according to Justice Thomas, the exclusionary rule, which says that evidence can't come into evidence to prove your guilt, doesn't apply to the states, which would allow police at the state level to do all kinds of terrible things. And that evidence comes in, that also would hurt racial minorities. All of his affirmative action cases hurt racial minorities. He is the only justice who, in Shelby County, people remember Shelby County, where the court struck down part of the Voting Rights Act. And what Justice Roberts said in that opinion was, we're striking it down as written. If Congress wants to reauthorize this provision with a more modern formula for determining which states come under the provisions of the act, they can do that, but they have to have a new process for that. Justice Thomas was the only member of the court who said, no, they can't do that either. This is unconstitutional, period, and Congress can't fix it. He is to the right of all the other justices on issues that involve racial minorities, and he has been the worst justice in modern times for racial minorities. And the reason I wrote that now is because of the news that broke last Friday that Justice Thomas hired somebody who's, as a law clerk, who said, I hate black people, I hate all black people.
And then invited her to move in with him and his wife.
No, the timeline is she was working for Charlie Kirk, who is equivalent to David Duke. Yeah. Charlie Kirk and David Duke are the same person.
Yeah.
This woman was his lieutenant. Right. She said, I hate black people, I hate all black people. She was fired for saying that, so she was too racist for David Duke. Think about that. because Charlie Kirk and David Duke are the same. And like within a week or 10 days, she's living with Clarence and Ginny Thomas, because Ginny Thomas was on the board of that racist organization. They took her in. Then Justice Thomas got her into Scalia Law School. Then Justice Thomas got the Chief Judge of the 11th Circuit, Bill Pryor, who we just talked about, to hire her, because Bill Pryor has sent 15 clerks to Justice Thomas. That's the most of any parent that's currently on the court. And now Justice Thomas hired her. And rather than write about that, although I start the piece talking about that, I then segue into, why would he do such a thing? Well, he's been doing things that hurt people of color his entire life.
You go on to mention, and didn't mention it here, but in your piece, probably the thing that did more damage is to people of color is the 2013. Oh, you did mention Shelby County. Sorry.
Yeah.
When he, voted to gut the Voting Rights Act, and
but
you
again,
say
he went far, but he went farther than all the other justices.
Justice Thomas would have gone further and would have held that Congress could not constitutionally enact a new law with a different formula to determine which states were most egregious offenders of voting rights. He also has voted to unduly limit the reach of different sections of the Voting Rights Act, making it harder for plaintiffs to sue states for racial discrimination in election procedures. Wow. This is a must-read piece. This is a really well-done piece. I'm sorry I hadn't read it before we started talking.
Well, actually, that is – I thank you for that. It was an important piece. But I got a private response that I put on Twitter.
Yeah, I saw that too. Go ahead.
So I wrote the piece, and then a black law professor who I've never met, maybe I met once or twice, but we're friends via email, basically. He's a great guy. He's a professor. I can't give any more identifying characteristics. He wanted to give a black person's perspective on what I wrote, which is totally fair, of course. And what he said was really powerful. And so I asked him if I could put it on Twitter anonymous. A black professor said this.
Yeah, you said I heard from a black law professor about my article.
Because he's worried about the same things I am, about being canceled if you go too far about this. But anyway, his position was basically, and again, this is him, not me. I would not say this as a white person. A black person said what his view, his and other people who he share his views on Justice Thomas is that he's really kind of embarrassed to be black, that he feels that a lot of black people in America, this is this guy writing, that Justice Thomas feels that a lot of black people in America are lazy and don't work hard, and he really hates them. And he hates them whether it's subconsciously or, I mean, since he invited someone to live in his house who said, I hate all black people, it might be that it's not subconscious. It's very conscious. But leaving that aside.
And he married that white lady. Yeah. I said it.
Yeah. Yeah. So I would urge people, if you don't read my piece, at least go to my Twitter feed and read what this guy said, because it's really powerful.
All right. Well, go read that on Twitter and read the piece and share it with your friends. And so I've had
a problem for the last 6 months, which is, especially with the Trump case in Georgia, I'm not saying this to brag. I do, 1, 2, or 3 interviews a day, basically.
Look at you.
And sometimes when I do them on my phone, it's very disturbing to the interviewer because I have all these notifications come across my phone.
Blurps and bleeps every time you get a text or an email kind of thing?
Yes.
Yeah.
Yes. So before we started today, Pete said, Eric, are you on your phone? And I said, yes, we do this on my phone. And Pete said, well, we can fix your notifications. And Eric said, really?
Yeah.
And Pete said, yes. And 3 seconds later, except for notifications from my children, because that's in case of emergency, those notifications have now been fixed. So now, thanks to Pete's technological expertise, I can now go out in the world.
By the way, my technological expertise was take your thumb and swipe it from the top of your phone down. It'll bring a window down. Do you see? And I said this. Do you see a moon picture of a moon? He goes, yes. I go, touch it with your thumb. And then he said, you're a genius. And I said, sure am. Thanks for joining me.
I'd like to remind the audience that I'm 65 years old. And I think I've done not terribly with technology.
Is that a moon picture?
Thank you, my friend. I have to run. Thank you.
Bye-bye. Thank you.
That's great.
And there he goes, Eric Segall stopping by, sharing all his perspectives. I always urge you to go see other perspectives because they are legal and interpretation, but we love when he's able to join us usually often on short notice, and he's a great contributor to the program. Feel free to reach out to him privately. I'm sure he'll get back to you. If for some reason he doesn't, let me know, and I'll harass him. That is eSpin Segall on Twitter and TikTok. Listen to his podcast, Supreme Myths, and of course, get his books and read that article about Clarence Thomas. That is all I've got for this special episode of Stand Up. I hope to see you, talk to you, hear from you later, because if you're a member of the Stand Up community, you are never alone. Thank you for your support, and go tell your friends. Bye-bye.
You've been sitting so long, you got the creaky knees, you got to stand up. Stand up. I think you're driving wheels with leaking grease. Boy, you better stand up. Stand up. Well, there's a whole lot more of us who know what's right. They'll keep door, and if it keeps in sight, you got to open up the window to let in some light. You gotta stand up. That's right. We got to rise up. You got to stand up. You gotta stare the devil straight in the eye. We got to let him know it's his turn to go. See it clear when all you hear is a lie. So get up off of your butt, get down off of your fence.